into the show. We've kind of been on this crusade talking about language and words and how important they are, especially when it's being applied to law. So we have also had a few episodes discussing a new lawsuit and some things kind of involving a really interesting intersection. I have to say that slowly. Of a few things, social media, free speech, freedom of religion, and civil rights are all kind of being combined into I wouldn't say a perfect storm, but definitely a storm and controversy created by Studio 8 Hair Lab over in Traverse City. Today, I like to say, illustrious attorney. He won't say that.
I won't say that.
David Delaney. Many of you probably will recognize, he's been on the podcast before. He is the Iron Pigs attorney, so he has represented me and the Iron Pig in several proceedings in the last 4 years now, we almost have to say. And a lot of those things have been around the way that words are interpreted. For us in the Iron Pig, it was the gathering of people for any purpose and may establish procedures. That language right there was construed to do all kinds of crazy things. So here along comes another case, and we've talked about it before with Studio 8, but I came across a clip on the news, and I want to play it real quick, and then we'll talk about exactly this confluence of all of these things, and actually the simplicity of Studio 8's lawsuit. Can't really even call it a countersuit, but a lawsuit that's coming out. And again, I don't. Trigger warnings aren't exactly what I want to say, but there. I do want to warn you. Listen, you don't need to agree with anything that Studio 8 has said on their Facebook page, but you're going to find out that it's being misconstrued in a lot of different ways. And I just want to play this real quick, and we'll take it from there.
All right. Well, over the summer, a hair salon in Traverse City received repeated complaints of discrimination.
This week, formal charges were filed against Studio 8 Hair Lab. Our Elle Myers joins us now from the Capitol in Lansing with more on the case.
The Michigan Department of Civil Rights filed discrimination charges against a hair salon in Traverse City over social media posts that said the salon wouldn't service LGBTQ clients. Now, the department is arguing that those social media posts are a violation of our state's Elliott Larson Civil Rights Act.
Studio 8 violated the law by denying their services to specific individuals based on sex. In this case, the respondent made sure the people in her community and beyond knew her position by publishing comments on social media, spelling out the people she would refuse to serve and why.
According to the Department of Civil Rights, Studio 8 had 21 complaints filed against them since July of this year. The salon posting that if a person identifies as, quote, anything other than a man/woman, please seek services at a local pet groomer, end quote. This current formal case of discrimination is based on 3 of those cases.
So our perspective on bringing the discrimination case against the salon is this. We have to enforce the laws of our state, right? And that's what the Department of Civil Rights is doing. They are enforcing the laws of our state. They're enforcing our Constitution.
The Elliott Larson Civil Rights Act was expanded earlier this year. The 1976 law already prohibited discrimination on the basis of gender, but was further expanded to include sexual orientation, gender identity, and gender expression.
It is important to say that the owner of Studio 8 need not literally to have shoved someone out of her doors to be found in violation of ELCRA.
Now that the charge of discrimination is filed, the department tells me the next step in the process is a public hearing. For now, reporting in Lansing, I'm Elle Myers, CBS News, Detroit.
Okay, so there we have, in a nutshell, I actually have a lot of issues with that reporting right there, but that's not really what I want to talk about. I just wanted to remind everybody exactly kind of what this case was about from the Department of Civil Rights and the 3 individuals that have filed complaints against her. So again, I want to welcome back in Dave Delaney to kind of give what I always like to say, we always like to say, kind of a breakdown for the guy on the other side of the bar. These are important issues. Mainly that there are people that are seeking money damages for something that they read on the internet. That's something that I find crazy and wildly fascinating, but something that is also being kind of left out of some of this. But you guys didn't come here to get my opinion. I want to hear from the legal side of it. Studio 8's representation, Dave Delaney. I've read a lot of this stuff, but you have an amazing way of breaking things down. So I figured to have you in and try and coach me up on some of this and some folks out there too.
Oh, always a pleasure to be here with you, Ian. And, a number of cases do come across our desks, but we only pick the ones. I try to pick the ones that deal with the Constitution.
Or what was it recently said that you are on the front lines of the culture wars?
Yes.
I think because, you represented at least 15 different
correct.
groups or individuals in school mask mandate cases. Obviously, the Iron Pig case was pretty big to do. So I found that kind of entertaining, and it certainly wasn't my go-to thing. That's not why I chose the battle, and I don't think that's why the parents in the mask mandate cases, and I don't think that's why Studio 8 has entered this battle either, to be a culture warrior, if you will. But nonetheless, I appreciate your point of view.
If the case impacts primarily the Michigan Constitution, which in many ways is a mirror of the U.S. Constitution, then I'm going to be interested in it. We talked before about the separation of powers, and I think that I want to revisit that just briefly. It's not the most interesting conversation you can have at a cocktail party, but it is always going to be important, and it's very important now. And so James Madison took the king's power. He was the sole decider of all issues. He wrote the laws, he interpreted the laws, and he enforced the law. And James Madison broke that up into three parts. The legislature writes the law. The executive branch, which is the governor and the president and all the agencies, they enforce the law. That's all they do. And then the judiciary interprets the law. And being able to master those three divisions is difficult because they tend to encroach on each other. I'll give you a couple of examples. The Flint water crisis, irrespective of the tragedy that occurred there, a judge issued the charge in that case under a law written by the legislature. But the courts ultimately set that aside because judges interpret, they don't enforce the law. The emergency powers in Michigan were laws written by the governor, and that was set aside because they don't write the law. And so the legislature probably does the least encroaching, but have the most difficult task, and that is writing laws, which the courts interpret. And
it's designed not to be easy.
No.
In my opinion and interpretation.
It's the most important branch in my view, and the state legislatures, I think, have the most important job. But those are the things that tell us what we can do and what we can't do, and it restricts our liberty, so it's the most important area of the law writing in this case. Just by way of comparison, the Constitution, the U.S. Constitution, and as developed by all the 50 states, the Constitution defines the rights of the government. And what are those rights? We just discussed them: legislature, executive, and judicial. Now, what's the Bill of Rights? The Bill of Rights limits those powers of the government. Okay, First Amendment, freedom of speech, freedom of religion, freedom of press. Second Amendment, the right to bear arms, The Fourth Amendment, search and seizure. Fifth Amendment, dealing with self-incrimination. Sixth Amendment, right to counsel. Seventh Amendment, right to a jury. So those are the rights of the people, and those limit the power of the government. So going back to what you said about the guy at the bar, when an issue is presented to you and you don't know what you just heard, that creates a problem. Okay. Right. So in the video clip, there were a number of things I disagreed with because it reimagines the facts and stated things that did not occur. I'll give you an example. If two people at the bar are watching the Lions game and there's a catch in the end zone, we don't know whether he was inbounds or not, at least those two people two gentlemen, two ladies, what have you, can look at the same video in slow motion and make determinations from there. If I'm just coming into the bar and you're explaining to me what just happened on the TV, but I can't see it, then I have to rely on what you saw. I got to see it to know what happened so I can argue over it. So let's move forward to this case. We have something that's called a public accommodation law, okay, written by the legislature, enforced by the executive, and it's going to be interpreted by the courts. Now, what is a public accommodation law? Well, the primary purpose of those laws, going back to the 50s and even into the 1800s, quite frankly, was that people of race should be allowed, irrespective of their race, to get a hamburger, to get a cup of coffee. And I think everyone is completely acceptable of that. The next category was religion. And I don't think you see as much of that, but you certainly see it. But I don't think that anyone that comes to your restaurant, irrespective of their religion, sometimes it's obvious and sometimes it's not, based on attire, that they can be refused service. Then the next issue was sex. And what they meant by that initially was gender. So in the 70s, we didn't want corporations only hiring men. Women should be allowed, and they had lawsuits, and the court said yes. Just because a person is a woman and just because a person is a man doesn't mean you can discriminate. They should be able to get the employment.
A protected class.
Exactly.
Okay.
So now we're into an expansion of that area. And that expansion includes sexual orientation, which means same-sex marriage, and the newest category, gender identity. A person is born with a gender and wants to relate to a different gender. In Michigan, they have divided the law into two sections. And those two sections are denying service. And the second section is communicating that you're going to deny service. Mm-hmm. This is a law that was drafted in 1976. Facebook was not invented or created until 2004. I think that's when Facebook was launched. But the internet and Facebook came after this law was drafted. And so what occurred in this case was Studio 8 put on Facebook their position about gender identity. Mm-hmm. Studio 8 did not refuse to cut anyone's hair. Nobody was refused service. So where does it put this case? It puts it into a pure speech case. The First Amendment in the U.S. Constitution, and that's Article 1 in the Michigan Constitution, has a very, very good batting average. It's up over 900, meaning that pure speech is protected in America. We're allowed to say what we want with only some limitations. And those limitations include imminent lawless action. You cannot go on Facebook and specifically threaten a politician, your ex-spouse, your neighbor, because that's not going to be protected. Defamatory remarks, things that are untrue about someone. I know.
I'm familiar with some of that.
But then it gets into defamation is not easy to prove because you have to show the malicious intent and things like that. And then some advertisements are not protected. But, and it's for probably another podcast, the number of cases that the U.S. Supreme Court has heard in which free speech has won, in addition to freedom of religion, okay? And in this case, Studio 8 asserts that God created male and God created female, and that is Studio 8's prerogative to have those views, as much as it is someone to have a sexual orientation or a gender identity. The challenge is that the government is intervening here and telling someone what to say. So
Compelled speech.
compelled speech.
Yeah.
Exactly.
I've talked about that before, and it's one of those things. It's why I think this is this confluence of all of these things coming together, social media, that to me is why this is so important. I think that this Facebook post was, again, whether you agree with it or not, on its face, she enumerated some things very specifically. If you identify as anything other than a man or woman, please seek services at a local pet groomer. The outrage was that she was suggesting, and this is not what I think, this is what others have. I mean, I've read them, I've seen them, I've seen all the news reports. People are trying to suggest that she is saying that a transgender person, it is basically an animal or something crazy like that. And that's actually really not what she's saying. It actually looks like she has read Elliot Larson's Civil Rights Act and specifically said anything other than a man or a woman. We've talked before about the definition on previous podcasts. Merriam-Webster's dictionary, pretty much says, you identify as either a man or a woman. And she says that right here. But pure speech, compelled speech, that's the thing that I'm on the lookout for right now. And I think there's this huge surge to start compelling people. I see it all the time online. These TikTok influencers are going to, there's a Delta issue the other day with somebody that was associated with Dylan Mulvaney, the Bud Light character, who is transgender. This gentleman was at the airport and was filming himself being misgendered by a Delta employee at the counter. It ended up having the exact opposite effect and sort of made this fella at Delta, who was just basically standing up on logic, and the fella that was recording was gravely upset that he was being purposefully misgendered. And this is sort of where this thing, I think, is headed, is to try and weaponize some of these things within civil rights protections that have real meaningful value around race and sex and gender. And now it's kind of being siphoned off to the side to be used in this sort of way. Again, there are 3 people that have filed civil rights complaints. Apparently there are many, many more, according to NBCR. But these people want money for something they read on the internet. I can't stress that enough. They want money for something that they read on the internet. So if this is allowed, where does it go from there? This is why I'm talking about it. This is why this is maybe the 3rd or 4th podcast that we're talking about it. So compelled speech to me, sorry I'm ranting, but compelled speech to me is something that is totally the antithesis of the First Amendment.
And you got ahead of me on the money damages. And let's go back to the Detroit Lions, because they're winning.
Woo-hoo.
I won't cover the Pistons and the Red Wings.
Hey, the Pistons, they're setting records. They're setting the wrong records. But
I went on holiday vacation. I came back, and the Red Wings went on this skid. So don't quote me on the rules for a fair catch, okay? But let me just use this as an analogy. So you show me the catch, and you say to me, I think it's not a good catch. Now I'm going to say to you, what are the rules? Okay, here's the rules. Number 1, both feet have to be in bounds. I think that's the rule. It may just be 1, but let's just go with this.
College is 1
and pros
maybe
is
pros
yes.
2.
The next question I'm going to ask you is, okay, what do you mean by in bounds? Well, neither of the shoes can touch the white line. Okay, now I'm watching the video. I look at his feet, and I can make a determination as to whether he was in bounds or not. What else? Can his body be out of bounds? Yes. but his feet have to be inbounds.
Control of the ball.
Control of the ball is next. Okay, now that gets a little subjective, okay? But anyway, you show me the definition of control. I look at the player, he's coveting the ball. He's not juggling the ball. I watch it in fast and slow. Once I know the rules, then I can make a determination on whether he was inbounds or out of bounds. But keep in mind, this is sports. As passionate as I am about sports, in the end, they don't win the game and life goes on.
Right.
This is different. This is the state of Michigan saying that they are going to take Studio 8's license and they're going to put them out of business. Okay, that's serious. That's not turn the football game off. The Lions lost. We're all upset. And we're passionate about it. But remember, it's still just a game.
An executive branch state agency.
Right. Number two, they're going to fine Studio 8. Number three, the individuals, and we'll cover standing in a moment, that are complaining are saying they suffered emotional distress and mental anguish from reading a Facebook post that did not include their name, their family's name, the names of anybody they know, not their employer, not where they live, and there was no damage to them, but they have their hand out requesting a check. And if they have standing, who doesn't have standing in this case? So discrimination laws penalize conduct. They do not penalize speech. So let's talk about the definitions, and then I want to give you a real example, which was the Colorado K case.
So we're coming up against civil rights
yes,
versus free speech.
Yes.
Right.
Correct.
I mean,
and freedom of religion.
and freedom of religion.
Right. And are those defenses to the accommodation laws? And they're starting to be. Let's take the issue of race. I don't think there's any cases out there that say the Bible tells you not to serve a certain race, Irish, Italian, you pick any race you want. The courts are going to reject that because the Bible doesn't talk about that. The Bible doesn't say that a person's race is biblical. Religion, of course, the Bible is religion, right? And so we recognize all religion. So there's really no defense there. And I think going back to the 70s, to say the Bible teaches me that I can't hire women to work as waitresses, I can only hire men, is another one that would be rejected. But now we're in an area that does implicate the Bible. This case does not involve sexual orientation, which is same-sex marriage. It does involve gender identity. But let's talk about sexual orientation just for a moment because it formed the basis of back-to-back U.S. Supreme Court wins for the First Amendment. In Colorado, the Masterpiece Cake Shop, two gentlemen went into his bake shop and said, we're both males, we're going to be getting married. And the cake shop owner said, I will sell you any cake product that you want. I'll sell you a birthday cake. I'll sell you a donut. I'll sell you anything, but I will not sell you a wedding cake.
Is this 303?
That's coming
That's
next.
the mission.
Yes.
Okay, yeah, okay.
This is the Masterpiece Cake Shop cake.
Yeah, okay,
yes.
sorry.
Because for him to make that cake, he's endorsing same-sex marriage. I have no position on gender identity, and I have no position on sexual orientation or same-sex marriage. I have a position on the Constitution. He told them that it violates my religious beliefs to share your views of marriage with you. I don't agree with that. The state of Colorado hammered that baker with fines and costs, and they came after him. The U.S. Supreme Court said that, number one, the baker denied service, but because his cake spoke, it was speech, that the First Amendment protected him. They did so on religious grounds, and that is this. The government cannot compel you to violate your religious views. So he won. Now, that case was decided on religion. It's very rare for the Supreme Court to take a similar case years later. So suppose the Supreme Court, U.S. Supreme Court visits when the police can pull your car over. They're going to do it once and tell you what the rules are, and then they'll be done with it for a long time. They're not going to keep taking those types of cases because they've already said to you what the probable cause is and is not. But immediately, I say immediately, maybe 3 or 4 years later, they took another sexual orientation, same-sex marriage case. Why? Because the first case was based upon religion. And some of the justices said, hey, what about free speech? We cover that too? So that's a 303 case.
Okay, yeah.
She's Colorado. She has a website, strictly website, in which you can go to the website and here is a marriage. And these are the people getting married. And this is where they're getting married. And are they going to have children? This is their names. And so it's a website that you can, what do I register? Everything is going to be on there. And so she too denied service. They came in and said, we would like same-sex marriage. And she said no. And again, Colorado was going to impose these complaints on her, but she went right to court. Because the idea now is before the agency can come for you, you can now go to court and get your rights established. Another win for the First Amendment, but this time under free speech, because that website was pure speech. And on the website, she said, I do not support same-sex marriage because it violates my religious beliefs. Why? Because she believes that the union for God is a man marrying a woman. It doesn't matter whether she's right. The same-sex marriage people could be right too, but she's entitled to the same respect that they are.
Right. That's key.
That's right. So if it is now lawful to have same-sex marriage, and we respect that, and that's what they want to do. But we must afford the same respect to people that don't believe in that. And the government cannot be the referee that says, I support same-sex marriage, but you I don't support, and then penalize them.
Right.
This is the whole core of leaving England so that we can have our religious views and we can speak our mind about things. And
the separation of church and state.
Exactly. Right. And
to me, that's another big one that's going to be coming around here again in the next. Well, we got an election coming up here, so it's always thrust into the spotlight anyways.
And you can see how James Madison is at work here. The legislature drafted a law.
That's my boy.
Gorsuch, right? That said.
That's my other boy.
That said, you have to honor same-sex marriage. The legislature said that, and the executive branch enforced it, and the judiciary said no. So it balanced out. Now, in Michigan, there's a case called Roush World in which there were 2 denials of service. One for same-sex marriage and one for gender identity, as they call it, transgender. But the Supreme Court only ruled on the same-sex marriage issue. But
these are both Michigan Supreme Court cases?
Yes, Michigan Supreme Court cases, correct.
And the other 2 were U.S. Supreme Court out of Colorado.
That's correct.
Yep.
Now, the Roush World case, I thought, did a nice job for definitions, which the legislature adopted, I think. First of all, sex is whether one is a biological male or a biological female. I think I can accept that. You're born one or the other. It's on your birth certificate, required by the state of Michigan. And again, I don't have an opinion about any of this. I'm just going by what the definitions on the books say and what the courts have said about this. So number one,
this is the similar thing, right? When we were in court before, and we always said we're not going to argue the science, and we told everybody else don't argue the science, right? There was so much emotion around COVID and COVID science, and that's not what we were arguing, and that's not what is being argued here. Is whether gender is binary or it's a spectrum or any of that. That's not the conversation that we're trying to get into. Here, it's about the simple definition and how a person's religious views correlate with that definition as well.
Exactly. So once we explain that both feet have to be in. You have to have control of the ball. Once you know the rules, you should pretty much be able to look at the video and say whether it's right or wrong. And there's some disagreement because there's juggling and things like that. But these are the rules that we've been given. So number one, sex is whether a person is a biological male or female. Got it. Gender identity. Okay, that's the term that is now on the books in Michigan. Now let me stop for a second. You will hear people say transgender, LGBTQ plus, non-binary. I don't know what any of those things mean because they're not in the statute. I'm only going to do what's in front of me on this case. So gender identity is now in the statute. It's going to be effective in 2024. It's not for 2023. But let's go back to the Supreme Court, start at one piece at a time. Sex is born male or female. That's what the Supreme Court said, Michigan. That's not my opinion. Number two, gender identity. And I think the definition in Roush World is very clear. Someone who identifies with a gender different than the gender that he or she was born as. I got it. To me, those are bookends. You're born male or female, and you're welcome to become a male or a female. Perfect. Now I know what the rules are.
Yeah.
So the legislature adopted pretty much those definitions, as did the Traverse City ordinance. Okay, Gaylord can have an ordinance and Traverse City can have one.
Non-discrimination ordinance.
Exactly.
Yeah, yeah.
So you're welcome to have multiple levels. There's also a federal accommodation law, but it's in the Civil Rights Act, but doesn't have the teeth that the locals, and they wanted the local states to enforce, not so much the federal. It's not effective yet, but in 2024, sometime around February of next year, we're coming up on that, the law will be this. So we have race, religion, sex. We've added sexual orientation, same-sex marriage, doesn't apply here, gender identity. And they say this, it is gender-related identity, not an individual's assigned sex at birth. Okay, I got it. You're born with a gender and you changed your gender, but you're still a gender. Not my opinion. It's what it says.
Sure.
Traverse City ordinance, I think, is even more clear. The gender with which one identifies, regardless of that person's biological makeup. Okay, perfect. We got the rules. So everyone knows the rules now. You're born with a gender, but you can change your gender. That's it. Now, what did Studio 8 say? So Studio 8 said, now this is speech on Facebook. If a human identifies as anything other than a man/woman, please seek services at a local pet groomer. You're not welcome at this salon, period. Okay, so the law, the protected class is either a man or a woman, or a person that was a man that is now a woman, or was a woman is now a man. What would she say? If you identify as anything other than a man or a woman, well, that's not a protected class. If you're not a man or a woman, then what are you? Whatever you want to identify with. So I had to go to the dictionary and look up, if you're not an individual or a person, you're an animal or a thing. Now, people think that I'm being flippant. I'm not. That is looking at the law here. And what Studio 8 was saying is people that are identifying as personal property or animals, I don't agree with, because the Bible teaches that you are born a man or a woman. And most importantly, no one came to Studio 8 to get their hair cut. She's allowed to go on Facebook and speak her mind about her free speech, about her beliefs about the law, and articulate that. And because she did, the government wants to take her license. They want to fine her. They'll want her to write a letter of apology. She'll have to go to counseling with the state of Michigan, and she'll have to pay people who read this on Facebook. But let's talk about that Facebook for a second. let's talk about that Facebook for a second. What is standing? That means skin in the game. Okay. So I go to a restaurant, not the Iron Pig, and I go with my good friend, and he gets food poisoning and he gets sick. I sue the restaurant. Can I? No, I don't have skin in the game. Well, I was with him. He got sick.
Right.
You have to have skin in the game. Okay. So let's make it more simple. A person of race is refused service at a Coney Island in Detroit because of their race. That person, I believe, has violated the accommodation law and is entitled to damages and has skin in the game here. Let's talk about this nondescript Facebook post. Number one, it does not address a protected class.
Yep.
The law protects people, and it protects a certain type of people. And what Studio 8 said was that if you identify as something other than a man or a woman, and the law says that you were once a man or a woman and are now a different gender. That's not what Studio 8 said. But irrespective of that, it's free speech. And we start talking about non-binary. That's one of the complainants. Mm-hmm. What does that mean? I have no idea. Does that mean the person has no gender? They're not a male or a female? The legislature in Michigan, if they want that to be a protected class, then go back and change the law. Okay? But even if they did, okay, even if they did, this is still protected speech. Okay? This is First Amendment, your right to air your grievances here. Now that we understand what standing is, here's this question. Who does not have standing under the claims of the state of Michigan? In other words, what about an 8-year-old boy in North Korea? Can he see the Facebook post saying that I identify as a woman or I identify as whatever I want to identify as and I want damages? Mm-hmm. Yes. Who doesn't have standing?
Right.
Everybody. There's no one on the planet that doesn't. Anyone that can read and write can see that Facebook post. So we're talking hundreds and hundreds of thousands of people. Anybody. I could read the Facebook post and say I identify as fill in the blank and see we're back to the definitional problems. If the definition's about whether it's a fair catch or not clear. And
consequently, by the way,
yes, right.
Sorry to interrupt you,
no,
but it actually has, and I hate this word, literally been read by hundreds of thousands of people because it went viral and news outlets picked up on it and pushed it.
Right.
So, I mean, there have been hundreds of thousands of people that have read that very statement right there. So, yeah, where does it end?
I think the other difficulty is these new categories of sexual orientation and gender identity are important to those people. But I think that gender identity gets into an area that is the most difficult to put a glove on. Mm-hmm. I think that clearly you can establish a person's race and you can establish a person's religion. You know, if you researched me, you would say, okay, Dave's Catholic and Dave's Irish. You'd be able to find that out. And then gender, sex under the act. Okay. Mm-hmm. You'd be able to consult with a doctor and say, okay, which male or female. I also think sexual orientation is also establishable. Get a marriage certificate, interview their friends. Yes, they are in a relationship. They have a same-sex
history
marriage.
Of behavior.
Yes, right. So there's no question that there are people that are the same sex that are married. That's questionable. The gender identity, and I'm not saying it's not a protected class, is simply identify. And that can change anytime. I was a male, I was a female. And the point I'm trying to make is not criticizing that area, is that the legislature needs to bear down on that area so that we know. And so in one of the briefs I filed in this case, I have a section called No Pets Allowed. So if that sign is in a window of a restaurant and I identify as a pet, do I have cause of action?
Right.
And none of us are being flippant here. We need clear and precise rules. Why? Because we want the Lions to win. Yes, we do, even though I'm a Dolphins fan. So we'll see what happens there. Because what's on the table here is everybody on the planet having standing, closing my client's business, making her pay fines and costs, castigating her in the press when she's saying that I followed the rules, number one, because looking at your definitions. Let's talk about that for a second. Right now in 2023, the word gender identity is not on the books. So doesn't even apply.
Right.
They're going to say, oh, well, that's because what's on the books now? Race, religion, and sex. That's it. What does sex mean? Well, don't ask that question to the wrong person, right? You got a different answer. But what it means is male or female at birth. What's your gender? That's what it means. That's it. So that's all that's on the books. The Department of Civil Rights is saying, well, we interpret the word sex to mean gender identity. The Michigan Supreme Court didn't get to that one. They only dealt with sexual orientation, same-sex marriage. That's all they ruled on. They talked about gender identity, and then the legislature adopted it. But it won't be the law until 2024. So I have a list of reasons that this case cannot be pursued by the state of Michigan. One of which, in no particular order, is that the law isn't even going to be effective until 2024. This was made in 2023.
Right.
That alone nullifies it. But number two, let's assume it's 2024 and that these definitions were on the books at the time. They don't cover what Studio 8 said. Because if a person, hypothetically, identifies as anything other than a man or a woman, well, that's not a protected class. So that's number two on the books. Before we even get to free speech. Free speech defeats, if everything the state says is true, free speech defeats that because nobody was denied service. And look at Colorado. They denied service. Both of those cases won on religion and free speech. So if they can win denying service because they had free speech components and Studio 8 statements are pure free speech.
Right.
And I've already given you one of two definitional reasons that they would be defeated in this case. then the free speech prevails. Ask the city of East Lansing how that went. When a farmer's market was held and they refused to allow a business to come in and set up at the farm market. Why? Because that company posted on Facebook that they do not support same-sex marriage. And when they come into this farm group, they're going to make that clear. And the city of East Lansing said, no thanks. We're not going to give you a permit. Don't even bother showing up. That cost the city of East Lansing in December of this year $800,000 of taxpayer money. Why? And I gave you a copy of the 2-page order because they violated the free speech and the freedom of religion of this business that wanted to come in. And it's no mistake that James Madison made free speech and freedom of religion number one.
Yep.
It's before guns, before the right to counsel, before anything else. It's the First Amendment. It's the most important thing to be able to speak your mind. And on a different podcast, we could go through the things that have been tolerated for free speech. We protect speech we hate, and we protect religions we're offended by. And Studio 8 has the right to speak their mind on these issues. And the state of Michigan might have a different focus on this if service was refused.
Yeah.
But remember, the baker refused and still won. Why? Because his refusal was premised on free speech and freedom of religion. We don't even have a denial in this case. We have a pure speech case. And the question for the state of Michigan and the city of Traverse City is, what are you going to tell the churchgoers in Detroit, in the UP, in Traverse City, in Gaylord, in Flint, in Grand Rapids about their right to exercise their freedom of religion.
Right.
Are you going to take the side of religion, or you're going to get into compelling people to violate their religious beliefs? Ask the city of East Lansing how that went. Colorado was 0 for 2 on this issue, and why the government would pick this battle simply on a Facebook post. And I have one more comment because I know you want to jump in. I want to talk about the statute. Oh, here it is. Okay. So the Colorado statute combines denial and saying things into one statute. Michigan separates it. Michigan has a section on denial. Don't deny the protected class. And don't even talk about denying the protected class. Don't print, don't circulate, don't post. But this is 1976.
Sure.
And the internet didn't come around till the 80s, and Facebook wasn't until about 2004. So they couldn't have predicted that. But in any event, it's a free speech issue. And the statute says this: don't print anything that says, and I'm paraphrasing, that you'll deny goods and services of a place of accommodation and that it will be refused. Now, there are very, very few laws based upon will be. And I put in my brief that que sera, sera, whatever will be, will be.
Yeah.
You can't say you're going to do something in the future and it be actionable, except the obvious. Okay, you go on Facebook and you say my ex, and I'm going to go out there next Friday and I'm going to do some harm. Imminent threats. Those are never supported.
Right.
We don't have that here. We have someone just expressing their mind. But this statute just says, in general, if you say something, if you print something that you will do something in the future, you're going to lose your license. You're going to pay a bunch of money. This whole section, which was Colorado, had the same section, and they lost twice.
Right.
So this section, not on denial, but on saying you're going to do something in the future, has never been tested in the state of Michigan. And it certainly shouldn't be tested in this area.
Interesting. You know, this whole thing, I can certainly suggest many reasons why this is the poster child for Elliot Larson and the new amendment that was added this last year, and the fervor and everything. And like I said, the post going viral, and her, Christine herself, being attacked online. Her store has had some damage. She had some brief picketing out by her store across the street or something like that.
By the way, exercise of their First Amendment right.
Right, exactly.
And the
Imagine
media
that.
also, and I had to jump in. I know I've given you the floor. The media, and this case is about supporting the right of the media to exercise their First Amendment right.
Right.
And they've done it. I haven't agreed with it, but they have the right to do it. And so too, those that are expressing their gender identity and those that are expressing sexual orientation share the same First Amendment right. And we want them to have that right.
Yes.
I want the judge in this case. I want the attorneys in this case. I want all the citizens in the state of Michigan and the U.S. to all exercise their rights. But their rights are no greater or no less than Studio 8's.
Right, exactly. And I think that is what is being lost in so many of these kinds of cases. Rausch World, the Cake case. There's just not equal footing. You know, they're trying to sort of play favorites, but they're forgetting that some of this stuff shouldn't even be considered, right? It's like I said, I find it fascinating, the confluence of something said on social media, the new amendment with Elliot Larson here in Michigan, all of these things, and an executive branch agency that is trying to come in and punish a private business and a citizen. There's so many things that are common from this case and from the Iron Pig case, you know, with the way that people are treating her online and then the support that she is also receiving from other like-minded people, because she's not on an island by herself. She may feel like that, but she has received tremendous support for saying this online. Much in the same way that, I mean, the reason why the lights are still on and we're sitting here doing a podcast talking about these things is because of that support that came in. And it's easy to focus on the negative stuff, but the reason why I want to talk about this is to show and to shine a light on the actual sort of facts. And of course, people are going, well, it's not the facts. These are actually the facts in the case, and that's why I thought it was compelling to play that news clip up front to show the narrative that is coming from the top down and the reason why there is so much fervor. And it's worth noting that in the rest of Studio 8's comments, she was upset about 2 House bills that were being considered at the time that, if my memory serves, it had something to do, again, with compelling speech regarding the use of pronouns or something to that effect.
Correct, yes.
And I don't want to put any words in Christine's mouth, but I believe that's what, and it shows in the Facebook post, but that is why I believe that she chose specifically to use the words man/woman. If you identify as anything other than a man or woman, go get services from a pet groomer.
And let me interject here. Studio 8 believes that it's not just enough to have the religious views, but to speak those religious views.
Yeah.
And she spoke them in a very forward way. And that doesn't matter. She could have not used certain terminology, but it's immaterial in this case. If you look at the history of the First Amendment, and maybe on a separate podcast we'll do that, some very offensive things have been said.
Yeah.
And the courts have to allow that. We have to allow the speech, not the conduct. And so Studio 8 put their foot down about how strongly they felt about their religious views, that God created man and he created woman. And they want to espouse those views, and they have the right to, and they don't have to necessarily sugarcoat what they said, and they did not.
So where in this process, so 3 individuals filed civil rights complaints. You guys have filed a lawsuit locally in Grand Traverse County against the 3 individuals from the Department of Civil Rights and the city of Traverse City. Is that correct?
Yep. And now the Michigan Department of Civil Rights
and now
has been joined.
Okay.
And I'm just getting that amended complaint back, so I'll be sending that down to the department.
So you guys are kind of in a briefing process, right?
Yeah, and that's a great segue question. And before I get there, I want to come right back to the guy at the bar. So now the questions are, what exactly was said? Now we know. Okay. We know we had the video of the catch. Got it. What are the rules? Now you know the rules. Okay. So this was said. It didn't violate the rules. The case ends there. But even if we gave the government its due, that what was said was a violation of the rules in a vacuum, then the question becomes, does the law even apply because of First Amendment rights and religious rights? If you look at the cake case, for example, you could make the argument, now wait a minute, Colorado did not allow you to refuse service for a same-sex couple. If we stop there, Colorado wins. They're the same sex, 2 gentlemen. They wanted a wedding cake. You wouldn't make the wedding cake case closed. Mm-hmm. If we were in Russia, but we're not. And so he did lose the first part. But why did he win? Because of free speech and because of religion. So before we even get to those, we know that the law doesn't even apply to this circumstance. Now, to your point, The executive branch, as we have discussed in other podcasts, is loaded with agencies. The Department of Health, the DNR, the DEQ, and at the federal level, the EPA, OSHA, and they have a local in Michigan, MyOSHA. Those agencies are in charge of enforcing the law. They're the little soldiers, if you will, of the executive branch. And in some cases, that's okay. But they cannot go too far afield. They can't write laws. It used to be that you had to get on the agency train. You did.
Right.
Iron Pig had to go through the Liquor Control Commission, the Food and Beverage Regulation, which is MDARD, the Health Department, and all I could do was wait for you for the court. And when you got to the court, you won. Now, the U.S. Supreme Court has said, wait a minute. Why go through this agency? And at the federal level, it's 5 years sometimes. You are years. Why are we putting these people through agency cases when the agency cannot decide questions of constitutional law?
Right.
So if Studio 8 got on the agency train and I say to them, no, wait a minute, she has a First Amendment right, they turn the other way. We don't hear First Amendment right cases. Well, what kind of courtroom is that?
Right.
So now we go right to court. Now, Civil Rights Acts cases are unique, standalone of all the agencies in the state of Michigan. And that is that the Michigan Constitution has a carve-out that said civil rights violation, go right to court.
Yeah.
Okay? Don't have to wait for the agency. Some would interpret that to say, no, I mean, that's just to protected class people. It doesn't say that. The businesses too, okay? We're saying that the state of Michigan and Traverse City are incorrect in this case. Traverse City never flagged a violation, but they did report this to the state agency. We want to know, Traverse City, are you going to prosecute Studio 8 or not?
Right.
We can't just have you say, not at this time. I need to know because my client in Studio 8 want to restate these things. They want to state their religious beliefs. So what we did,
believe it or not, that happened with the Liquor Commission.
Right.
They came back literally 30 days later and found me again in violation for the exact same thing that we had already gone to court for.
Well, you had one agency saying, well, I wasn't a part of that case. That was a different agency. Right. So we want to be able to knock that down. Mm-hmm. So when the case began, it drifted down to Lansing, and the complaints were filed, and the agency was starting to warm up. Well, we knew they were going to issue a charge. You hear they were issued a charge. It's not a criminal charge. It's just an executive branch saying, we think you violated the law. And I think we've already covered why we don't think that's the case. Yeah. So we went right to Traverse City. And we joined Traverse City, and we joined the three individuals to say we didn't violate any laws. They don't apply to Studio 8. This is free speech. This is freedom of religion. But even taking those things off, I'm clear in my pleadings that Studio 8 should win because the law doesn't apply for the reasons we just said. That is, both feet were in bounds, and they had possession of the ball. We got the 7 points. But what came out of this was certain hair product companies saying we don't want to do business with Studio 8 because of the heat they took. Politicians weighed in, government officials weighed in and said, you're already guilty. You committed an act of discrimination when that never occurred in this case. And so we're asking Grand Traverse City courts to rule on this. In the meantime, we were the first one through the door with the court. After we went to court, then the agency came out and issued formal charges. This is an act of discrimination. You saw the press conference. Yeah. We've already covered why we don't think, and I think it's clear from their definitions, not my opinion about what these words mean. The Supreme Court and the legislature has spoken, and they don't apply to what my client said. But even if they did, she has a right of free speech.
Right. And
she didn't deny any service. So to pick this battle, so the Michigan Department of Civil Rights said, well, we're not a party to the case in Traverse City. I said, well, okay, you are now. Now, what difference does it make? Because even if my client got on the agency train in Lansing, When they're done, where does that case go? To the location of her business or where she lives? Where is that? Grand Traverse County. The entire Michigan Civil Rights Act says that the case will be litigated in the courts in your own backyard, which is what happened to you.
Yeah.
And we want that. We want the
Right.
business owners to be decided by local judges, not by Lansing. So this is just a fool's errand, if you will. And I don't mean that disparagingly toward the administrative proceeding. Why go through the administrative agency when we're going to end up in Traverse City anyway? So we have a hearing coming up in 2024 with the agency. And I'm going to tell them, and I've already told them in a brief that I filed, this case belongs in Grand Traverse County. And we have the right to go there first. The U.S. Supreme Court in 2023 already ruled on that and said, stop making these people live their life in an administrative court. That's not going to hear a constitutional question. What a waste of time.
Yeah.
So let's get back to the separation of powers and let the judges decide these cases. And so, you know, the agency case, I'm just going to ask the judge to close it and let it go to Traverse City. We're already there.
Yeah.
Or go ahead, make your ruling. And what they're going to do is ignore my Constitution, the most important rights that we all have, the First Amendment, they're not going to look at. Well, if that happened in Colorado, they would have lost.
Right.
So why are we spending all this time doing this? So if they want to hear it, fine. I'll just wait. I'm going to stand on the sidelines and let them take their case. And when they're done, I'm going to be back in Traverse City. And we've got a hearing coming up in February in Traverse City that lays all these issues out. Let me talk about standing again real quickly. You know, if you're making a list of reasons that the state and the government can't prevail, we're on 5 or 6 now.
Right, at least.
This is again decided by the U.S. Supreme Court, not 10 years ago, not 100 years ago, in December of 2023. And the American with Disabilities Act is kind of similar to a public accommodation.
Sure.
A person in a wheelchair should be able to get into the hotel. They're a protected class and they should have that accommodation. So what was happening was a person in Florida would go on Facebook. Sound familiar?
Yep.
Look at the business webpage and determine whether or not what they saw was a violation of the ADA. So if they saw steps going up to a hotel, but there was no ramp, that would be a violation. And they would sue the hotel, never having made a reservation, never have any intention. This was a hotel in New Hampshire, U.S. Supreme Court. This person's in Florida. And all they do is sue on Facebook postings. Sound familiar, right? The U.S. Supreme Court put an end to that. Said, you don't have standing. Okay. You have no intention to ever go. You didn't try to go there. If you went there, and this old motel was up on high stairs, they'd say, you have to be able to let them into your business. And they would have been denied service, and then they would have standing. Okay. But then the hotel could fight back if they can establish some defense to that. They're not going to be able to free speech or freedom of religion, but in any event. So the court said no. And the case got dismissed, and now a lot of that's going to stop. You have to actually be denied service. So another standing problem there, and I put that in my amended complaint, that these individuals that were on Facebook don't read it. Yeah. You weren't denied service, but they have their hand out asking for a check. Number 2, a place of accommodation is interpreted to mean bricks and mortar. Remember, this is 1976.
Sure.
Facebook is not a place of accommodation. There are already cases deciding that. So I don't need to make those arguments, but I just put them on the pile because I think Studio 8 wins just on the definitions alone. But even if Studio 8 doesn't prevail on any of those things, they prevail under the U.S. Supreme Court freedom of speech and also freedom of religion. also freedom of religion.
So, it's interesting going back to your analogy about, reviewing a football play. Technology has certainly changed the definitions and added to those rules of what is a catch. I mean, cameras have gotten so much better that you can see the moment a ball comes, and to further define what is. And I think that is slowly what is happening with some of these cases at the state Supreme Court, the federal Supreme Court, with the open social platforms like Twitter and Facebook and these other things. And in MCL 37.2302, they're talking about, they say the words post. And we know that not to be a Facebook post.
Right.
But these things are going to have further definition, just like the rules for what is a catch, to determine if it's a touchdown or inbounds or whatever. These kinds of things are just going to have to be, I mean, this is how, the judicial branch is going to change these things and force our legislators to go in and potentially amend this to specifically enumerate sex as between a man or a woman, or whatever the legislature ends up deciding, right? That's the great thing about the legislative branch. If we want to do something like that, we elect people that can, I mean, that's how Elliot Larson, that wasn't a petition drive, was it? No.
I don't know the history behind the act. I know it was 1976.
The amendment for last year, I don't think was. So anyways.
The Roush World Supreme Court said to the legislature, are you going to amend your act or not? I mean, and so the Michigan Supreme Court said that sex would include the definition of sexual orientation, same-sex marriage, but they didn't go into the gender identity area.
Right.
But it's now the law anyway. But in any event, again, the two issues are that what was put on Facebook doesn't apply to the law, because the law is a bookend. You're born with a gender and you can change your gender. And what Studio 8 said was, if you if a human identifies as anything other than a man or a woman, then I'm not going to accept your service. And what they were saying was this: don't come here and tell me that you're something that's not human, male or female.
Right.
Whatever that would be. A dog, a cat, a basketball, I don't know. But those are the words that were spoken, and they don't apply to the definitions. But even if they did, if everything lined up for the government, it's free speech.
It's free speech.
She's permitted to, and they call it advertising as if it was an ad in the newspaper, and it wasn't. Her Facebook post is pretty extensive.
Yeah.
She talks about grievances, which is one of the tests for free speech, that you're allowed to vocalize and disagree with any of these things that exist here. And it again has fallen into that category that's questionable. But I always try to get right back to the basics. Think about this. In Colorado, there was an actual denial of service. It wasn't just a Facebook post.
Right.
People came into the cake shop, two men who were going to get married, and they asked for a cake, and he said no. Well, as we said earlier, how could you win? It's an actual, so yes, denial of service can be one.
Right.
Under freedom of religion.
Despite what John Johnson said in that
exactly
in that little interview.
And when religion won, the justices said, what about free speech? Then came the 303 case, which was a pure website, and so if people have time, read those cases, and you'll see in the 303 case that the website was a denial of service. No question.
Right.
No, I will not prepare a website for same-sex marriage. Violates the protected class, does it not? But when a law of public accommodation collides with the Constitution, Justice Gorsuch said there is no question which will prevail. And that is the Constitution. And that's why those two cases, one, they denied, but they were able to assert free speech and freedom of religion. It's those areas that are causing the most consternation. That's not going to work on race.
Yeah.
I don't believe that Irish should be able to eat at a burger restaurant. Does the Bible really say that? You know, I don't believe that I should be able to serve Catholics. Okay, I don't believe in male or female, but the sexual orientation and the gender identity areas have created the most divisiveness. And gender identity hasn't been tested, but I'll say this: in Roush World case, the Michigan Supreme Court said, "Now hold on. Whether or not a person can assert religious beliefs, we do not decide." So they left that card on the table. And true, the U.S. Supreme Court in civil rights cases said, we think that under the Civil Rights Act, these definitions apply. And again, they said, except religion. Okay, so even if the government survives the definitional aspect, let's go to the basics. 2023, the law was not in effect. They survived that somehow. 2024, the law is in effect. They survived that somehow. They argue this isn't free speech. This is an advertisement in the newspaper. They survived that. How are they going to get by the assertion of religious beliefs when the courts have said in 2 Colorado cases that is something that we protect? You could almost argue that religious beliefs are protected greater than freedom of speech, but they're tied together in the same amendment of the Constitution. So is the government, as I said earlier, really going to come in here and say, we don't support free speech, and more importantly, we do not support freedom of religion?
Right. And I'm struggling since this whole thing has started, and I've been watching what you guys are going through, and reading all of these things. I'm trying to figure out if it's irony or if it's hypocrisy that this whole case is essentially silencing somebody's right to free speech because of somebody else's alleged civil rights are being violated. So ultimately what's happening is somebody's right to free speech and the right to their religion is being silenced by a state agency from 3 people that read something on the internet and are seeking money damages. Now, I don't know these people from anybody, and I'm not trying to disparage them, but it simply cannot be overlooked that they are looking for money damages for reading something on the internet. I just read something, I'm offended, now I'm going to file a civil rights complaint, and 24 or 5 other people are going to do the same thing, and I want money for something that I read on the internet. I cannot get past that aspect of the whole thing. And this is an attempt to silence somebody's free speech, whether you agree with it or not, whether you're a Detroit Tigers fan or not, right? Somebody says something online that disparages the Detroit. I'm just being ridiculous, but that's how ridiculous this all is. But having said that, there are people that this issue is important to. The trans, the binary, there are people out there that do identify this way, and that is the intent of the Civil Rights Act amendment last year. And I don't think for any moment that Christine was really actually trying to deny anybody's service. She's simply taking a position based on her religion, given what she's seeing in her culture area and what's going on. She asserted her belief. She asserted her right to free speech. She asserted her right to freedom of religion. And now an executive government branch agency is seeking to fine her on behalf of 3 people that read something on the internet.
Yep.
That to me is bonkers. Total bonkers. I understand why these people are attempting to do it. I want to dig a little bit more into potentially who might be funding or paying for legal fees and or potentially got these three individuals to file these complaints. The gal in the interview there we played up front. I'm going to dig into that a little bit more because I'm curious. I'm curious at why these people have chosen this battle that seems to be very, very unwinnable on its face. Are they that emotionally driven? And again, I understand, emotionally driven to take this case and use it as the example of why the Civil Rights Act was amended last year. That to me is what they're attempting to do. The politicians and the city officials that have jumped on and made comment as well, I feel like they are bandwagoning this thing, if you will. But I can't make clear enough that it is an important issue. These civil rights things are important issues, no matter what class you're talking about, marital status, race, religion, they're all important, and you shouldn't be taking one side or the other, because free speech is nearly absolute, right?
Correct.
You don't have to agree. You don't have to agree about what somebody is saying, but we should all agree that you have the right to say it, and the government shouldn't be punishing somebody for their free speech.
Exactly.
Give you the last word.
Well, your words are, your free speech is equally important here. And I keep coming back to the examples to make this as clear as possible, because you hear about what someone is recreating. For example, in the 303 Colorado case, the website designer, Justice Gorsuch said that the dissent is reimagining the facts. Okay, so I'll hear in the media, for example, that Studio 8 told transgender clients to go to a pet groomer. Now, hold on. First of all, no one was told anything. Okay. Number two, I don't know what they mean by transgender, because I only have a statute that says gender identity. Number three, they were not clients. Okay. But when you hear that, what you're believing is that a person went to Studio 8 and said, I am born a male and identify as a female. Can you please cut my hair? Studio 8 said, no, I don't agree with your description, and I will not cut your hair, go to a pet groomer. None of that happened. That's a reimagining the facts, right. Okay? And so that's why you want to look at the basics here. So back to Colorado. The cake shop owner has in front of him a birthday cake, and he has a wedding cake. And the two men come in, and he told them, I'll sell you a birthday cake. You can have a birthday. You may have the same birthday. I'll sell you two cakes, or you can share a cake. But I'm not endorsing your message. But I will not sell you the wedding cake. Now, wait a minute. He denied service. How can he prevail? And we're back to this idea of his freedom of religion. And to some degree, freedom of expression and freedom of speech. So denial, you wouldn't think denial could win. But in that case, they did. And the same thing with the web designer. So here, going back again to the basics, no service was denied. A person just spoke and said, if, hypothetically, a human being identifies as anything other than a man or a woman, I will not provide services. And the statute says will be. So we're talking about hypothetical on hypothetical. But even if it wasn't, you still have the free speech that exists here. And I think that one of the best examples I could think of is, if they still have them, remember the little coffee shop huts, like the little deer blinds, right?
Oh,
you
yeah.
drive up, right?
Mm-hmm.
And all they did had a pot of coffee and cups. That's all they had. Now forget about the ones that had donuts and stuff like that. And you would just pull up, and all you had to say was small, medium, or large cream and sugar. But let's leave that out. They just sell coffee, no cream, no sugar, just black coffee, and you're done. I think that business can never refuse service to anyone, okay, irrespective of race, religion, sex, sexual orientation, or gender identity, because it's a cup of coffee. They're not endorsing any of those messages. But remember, my example involves service, okay? We're talking about free speech here. And in the 303 case, which is the Colorado website, that's a service, right? But the Supreme Court said it's pure speech and you can't regulate it because of her religious beliefs. And I think the only two categories are sexual orientation and gender identity. They're going to have the most difficulties in those areas. But again, we're looking strictly at a speech issue. When I first came here, I was rereading the cake case, and Justice Thomas has some comments in there that I want to share because I think he articulates what we're talking about here. And he says, it is one thing to conclude that the Constitution protects a right to same-sex marriage, which it does. It is something else to portray everyone who does not share that view as bigoted. So you're welcome to support same-sex marriage, but you're also welcome to disagree with that. And that's what Studio 8 did, but in the gender identity area. I don't agree with it. But more importantly, she cited something that is not a protected class. But even if she did, it's still free speech.
Still free speech.
And she still didn't deny service. And even though the government will say, no, we can regulate that, I don't think so. They don't regulate the internet. They didn't regulate Facebook in 1976. But in any event, the final thing was, and we hadn't discussed this earlier, I went to the U.S. Department of Justice, the Civil Rights Division, and it says, what does discrimination in a place of public accommodation look like? In every one of them, a restaurant refuses to serve an Asian American family. Refuses to serve. A bar turns away a patron, refuses to serve. Now, this is from the U.S. Department of Justice website. 2 Asian American customers walk into a bar and are forced to wait an hour for service while white customers are served right away. Okay, in any event, it's denial of service. A hotel charges a certain race higher than another. That's act in conduct, okay? A club owner refuses entry to certain customers. A food stand employee at a sports stadium refuses to serve Chinese American customers. Okay, every one of them is about refusal of service. This is from the website of the U.S. Department of Civil Rights, who I'm quite confident takes very seriously their civil rights laws.
Sure.
But none of them talk about speech. And that essentially is the case. And so we'll be having a hearing with the agency in January or February of 2024, and with the circuit court also in February.
So it's going to be interesting to see. We can kind of see where they're trying to take it. We're going to be talking about this more as it comes along. Again, I think it's a confluence of so many crazy different things, and it's a really important issue for several reasons. But I appreciate you taking the time to break this down for us. We'll have many more conversations about it, I'm sure. It's going to, how do I want to say this? These issues are monumentally important given that free speech is the First Amendment, given that social media is the largest platform for free speech, regardless of which actual platform you're using. We also know that free speech by the federal government is being limited, and certain things are being funneled as dis or misinformation. the reason why this silly podcast even exists is to get the other side of the story, the full picture, all of the information, like you were saying before, not just one narrow view of it. So all of the information is out there, so anybody can make an informed decision on any of these kinds of issues. So we'll see. I mean, free speech is monumentally important. It's the reason why it's the First Amendment. Freedom of religion is monumentally important, regardless if you agree with what these people are saying or not. I'm not overly religious, so I would never go and say such a thing, but you know what? It doesn't matter because I stand behind Christine and Studio 8's right to be able to do so. So to me, that's where it is. Language is important. Here's a situation, again, where a law is being used and the language is being meandered and interpreted in such a way. And we'll keep an eye on these things as more and more of them come around, because we've seen a certain particular party using language over the years: climate change, climate disaster, global warming. Those are just a couple of things. And I think that this is a march towards that, to take these definitions and widen them out. And thankfully, we do have people, and not just, me or you or Studio 8 and Christine in this case, but many, many, many others are out there taking these issues to the courts. They're engaging in lawfare, if you will. And it's not cheap to do. And it's unfortunate that so many of these things have to be adjudicated the way that they are through state agencies, the way that they do. But either way, these are fascinating topics to look at. I love getting your opinion on things, and I love getting the baseline out there for people to understand exactly what is going on with something that is very, very, very important, especially going into an election year where so many things are in question and so many people want to run on this record or that record. I just find the whole thing fascinating. It is a culture thing that is definitely being injected here as well. We try to tamp that down a little bit, but I've rambled on enough. We got to get out of here because I'm pretty sure we're going on over an hour with this podcast, but we always do. We always do.
I have one more comment.
Yeah, go for it.
I want you to have the last word. And I have to tell you that what influences me the most is when I talk to the folks, the guy at the bar, the girl at the bar, my clients, because their opinion about things is much more important than mine. They're the jury, if you will. I want to know what the folks are thinking about these things. And as you speak, as has always happened in the cases that I'm involved with, you always trigger ideas for me. And that's so important to get outside of my zone of perception and to hear what it is that you want to say. And I had some more ideas here. And I still will give you the last word here. One of the things I said in my brief to both the court and to the agency was this. It is said this case is about transgenders, gender identity, and hatred. It is not. It is about whether the government may regulate the internet. They may not. It is about freedom of religion. It's about freedom of speech, all protected by the First Amendment. Which side is the government on? Is the government, your government, does not choose the unalienable rights of religion, it chooses tyranny. But let me add this. Quoting the U.S. Department of Justice, no reasonable person at a Lions game ordering a hot dog watches the vendor say, okay, here's your hot dog. And then to quote them, a Chinese American asks for a hot dog and they say no. Most reasonable people, rational people would say that's not right. You're going to sell that person a hot dog. Mm-hmm. Now, compare that to being able to simply speak your mind on Facebook. And anybody that's offended by that, you have to pay because they were offended. That's at the heart of the First Amendment in this case. Now, the government will tell you, no, wait a minute. What you said on Facebook violated state law And that's why you're responsible. But no state law can amend the Constitution. The Constitution runs the show,
Right.
not what the legislature did in response to the Constitution. And this is the final thing I wanted to say, then you can have the floor back. In a separate podcast, we can go through the 200 years of First Amendment cases in this country, of which the First Amendment won by religion or free speech. Every one of those cases, what the person said violated a statute, whether it was a criminal statute involving terrorism, involving civility. They all involve violations of statute. Otherwise, there wouldn't have been a case.
Right.
So for the government to come in and say, no, wait a minute, you can say what you want on Facebook, but don't violate a public accommodation law. No. Every one of these cases that are out there about protesting the draft, that violated state laws. It violated federal laws. Flag burning, okay, is speech. Okay, the laws were on the books. I'm getting into my First Amendment arguments here. That was speech because the person was speaking out against the war.
Right.
Now, I'm personally offended by flag burning. There's a whole bunch of other cases out there. So that person broke the law, but they prevailed. Why? Because the First Amendment said you can speak and burn a flag, as offensive as that is. So the idea that, no, wait a minute, we have a statute that doesn't allow you to speak your mind is irrelevant.
Right. This stuff is, I'm learning so much, by the way. Thank you. It's like a free master class in some of this stuff here. We'll be keeping an eye on this, a couple of the other cases that are going on, some other things that I'm going to end up getting your opinion on as they come down. We've got the Supreme Court looking at minimum wage issue that they actually took some oral arguments on a week or two ago. So we'll be finding out some more stuff on that. I'd love your opinion on that later. I'm pretty sure we have like 4 or 5 podcasts we already mentioned we could pull out of this, but this is how complex some of these things are, and they're very important. So, David, thank you again for taking the time. You guys, thanks for tuning in. If you have any questions, comments, drop them in below here. Make sure to subscribe everywhere you listen or watch a podcast, YouTube, Spotify, all those fun things. Be sure to check out Fuelcast TV at fuelcasttv.com. For David Delaney, I am Ian Murphy. Thank you for tuning in.
Thank you.